our June town hall. I'm Liz Swigert. I am honored to be the 2025 SCP president, and that means that I have the great honor of hosting our town halls, and we have a very exciting one for everybody today. We are joined by our guest, Erin Austin. Erin is a Harvard Law alum. She has more than 30 years of legal experience, and she does a lot of work in the field of intellectual property law. She is the founder and CEO of Think Beyond IP Legal Services, and she provides a variety of services to meet the needs of clients in the emerging and growing tech spaces, particularly when it comes to artificial intelligence, which is the subject that we are going to be tackling today. So this is an opportunity for us to hear from Erin, ask some questions, and learn more about what opportunities there are, but also what potential pitfalls may befall the unwary when it comes to using artificial intelligence tools to serve clients in the field of consulting psychology. So a special shout out to the newly minted Dr. Rachel for introducing me and us to Erin and allowing us to be the beneficiary of her great expertise. So without further ado, I'll ask that, it looks like everybody is, but please stay on mute unless you're asking a question. And with that, I will turn it over to Erin. Welcome, and thank you so much for being with us.
Thank you so much, Liz. Thank you, Rachel, for the introduction. And very excited to be here. Very excited about this topic. When Liz read my introduction, we went over a little bit before we came on live, and I realized that I haven't quite updated it to really focus so much on AI. And the way I really became an AI expert, and I'll use that term, is because many years of doing copyright law. And as you may know, that one of the early issues that pretty much everyone identified when they started using ChatGPT was the copyright issue. But we're going to focus more on like how we're using it in our businesses with our clients. So with that, I'm going to share my screen and get us going. And it's always something with me when I've got two screens. So hopefully I got the right one chosen. This is my slides, I hope. And I need to go to slideshow from the beginning. All right.
Slides look great.
Thank you. So if your inbox is anything at all like mine, it is absolutely full of either new AI tools or new AI functionality with the tools that we've been using all along. And, great opportunities with them. Absolutely. I am pro AI, which is why I'm here. But when we, as professionals who are handling the confidential information, the personal data of our clients, we have some extra considerations, not even to mention the additional regulatory hurdles of those of you who are covered entities under HIPAA as well. And so let's talk about the wonderful survey that Liz sent out, and that a couple of things got added today. So I did incorporate them to the best of my ability. But generally, like on the one side, these are the apps that you listed that you were using and that you're the most interested in. The three that came in today were Blueprint, Manus, and Opus Clip. And so I only had a chance to briefly look at those. They were new to me. But we're going to talk about them today. But when I first kind of looked at what apps that you were interested in, it looked very much like you were really interested in generative AI. But then I looked at your concerns. And your concerns were very different. They were much more about confidentiality and disclosure and kind of the ethical uses of it. How to not compromise anonymity and things of that nature. And so we will address all of those, but I'm glad that I got to see both, where the apps were that you're looking at, as well as the concerns that you have. But I think if I really kind of boil down what your concerns are trust. I mean, again, we are handling the confidential information of our clients, personal data of the employees. And so trust is a huge thing. And it's not so much about, frankly, with the ChatGPT issue, are they going to steal my stuff? But really, am I going to be breaching my obligations to my clients and to their employees? And so we are going to dig into confidentiality, accuracy. There are some questions about that, disclosure and consent, of course. And although no one used the term agentic AI or autonomous AI, you were talking about, kind of human factors and things like that, that also get us to the same place. So one of the things that you did not ask about is copyright law. Like nobody, well, that's not true. The very last comment that came in around noon today was about IP. And so, but I'd already decided that it would be, frankly, too much to try to cover today. But so I'm going to just very briefly give an overview of the copyright law issues regarding generative AI. And so one, with respect to the input, and this is something that you might have noticed is literally being litigated as we speak, and that there have been some recent rulings regarding, OpenAI's use of books that they did not have licenses to use, Meta's use, Anthropic's use, and it's whether or not copying someone's copyrighted work and putting it in the input and using it as training data without permission, whether or not that's an infringement. And so right now the law is fairly unsettled, but the cases that were literally decided last week point to that there will be a fair use determination with respect to that. But again, not settled. And then there's the issue with the output. And the Copyright Office has determined that, and it's in the statute, that in order to have copyright protection, the work has to be created by a human. And as of today, 2025, AI is not considered human. And so any output that is AI generated is not eligible for copyright protection. So essentially it's in the public domain, and therefore anyone can use it. And then we'll get into this a little bit more when we talk about the terms of use. But I want to just give that brief overview of copyright law. I have done, let me see here, I do LinkedIn Lives. And so, and I have, how do I get to, oh, over here. Let me find the chat, main chat. And there is a LinkedIn Live that I did that goes in deep regarding copyright law and AI issues. So we have legal issues and we have ethical issues when we are talking about these uses. Contractual obligations that we have. The terms of use, those are contracts. Even though you don't sign it, you agree to the terms when you use the platform, and those are binding contracts. Then we have our client agreements. What are we obligated to under those agreements? We have statutory issues. Copyright law, of course. Should have had state law in here too. So there's also state law. We're going to talk about that a little bit. But that generally is with respect to consent and disclosure. And then I put liability here regarding insurance, which is something that I've been interested in recently because it's come up. And I've been poking around. I'm not an insurance agent anyway, but poking around our insurance issues with respect to using AI as well. And then we have the ethical issues. Now, really, these are all, to the extent that there is not a contractual obligation or a statutory obligation with respect to our use, we still have ethical obligations. And so there's actually a fair amount of crossover regarding, even if we aren't required by law to disclose or request consent, that it still would be best practices to do so. And of course, bias is still an issue and will probably always be an issue with respect to AI usage. So let's start with terms of use. And so chat GPT, and this was a pop-up screen. This is a screenshot from my computer. I was actually, the background here is what I was actually asking it about. And this popped up. Now, this was not the first time that I used chat GPT. I don't know how far into my use of it that this popped up. I believe it popped up because people were confused and they didn't understand like what chat GPT is and what generative AI is. And so this was a little CYA for them to have this pop up. But one of the big things, and this is definitely about the legal issues and not about how to use AI, which really will depend on which platform you're using. But I do want to just say overall that generative AI should not be used for searches. It's not to be used for accuracy. It is predictive. It's taking your inquiry and it's using kind of the large language modeling to answer you the way that if you went down, the hall, if you are going to work in person, and you asked a colleague, like, hey, what do you think about this thing? And they would respond, I think this, and this, based on my experience and based on the information that they have downloaded, what they know. And that is the nature of a response from generative AI. So we want to make sure that we are careful about that. So I want to take a second to share what we're going to do. We're going to do a little exercise here in a minute where we will look at some terms of use. I don't know how many of you, if any of you, have ever read the terms of use of any website that you have used, but it is particularly important when you're using AI. Unless you have some sort of enterprise agreement, then you'll be using the online terms, and those online terms will tell us everything we need to know about who owns the input, the output, copyright infringement issues, whether they use it as training data, how they use it, can you opt out, accuracy. All these things are found in your terms of use. Terms of use are foundational. And so if you're going to use AI, you have to get comfortable looking at the terms of use. So I first want to, let me see here again. I'm going to unshare this so that I can have I not been sharing? Have I been sharing this whole time?
We've been looking at the terms of use or foundational slide.
Okay, great. Okay, it looks strange on my thing. Okay. So I'm now going to share. Where is it? Chat GPT. Okay, here we go. All right. It's going to be complicated. So these are the Chat GPT's terms of use. They are some of the most user-friendly. Not all of them are as user-friendly as Chat GPT's are. So you will see, just kind of some standard things you can and cannot do. And we're going to scroll down to the content. And so down here, it will talk about, what you put in, what you get out, and how the ownership works. Here, it explains that you're retaining ownership in your input and you own the output, which is an interesting way to put that, in that they don't claim ownership of it, but they also don't make any reps or warranties about whether or not they have any rights in that output, because that output could include work that is owned by a third party. And so as between you and AI, you own the output. Maybe similar, we're granting them a right to use their AI, your content, to improve their services, which includes adding it to their training data. There is a way to opt out. I don't know if any of you use ChatGPT. I do, and I tried the opt out very early on, and they penalize you, which it is what it is, in that it doesn't remember you. And so it doesn't remember all of your prior inquiries. And one of the value that I get from it, because I use it for content generation, I don't use it with my clients, but I use it for content generation. And so it knows me and knows what I talk about, and knows what I write about. It knows the drafts that I've gone through on my bio, that updated ones that haven't gotten onto my website. It knows all that stuff. So you can just pick up where you left off, and it knows everything. But the consequence of that is that it is all part of their training data. Again, I don't mind, because it's all going to be something for public consumption eventually. But that does matter depending on your use. It talks about the accuracy here. So the other big contractual obligation we have is to our clients directly. And so all of us, I'm sure, are signing agreements with our clients, and you'll be sharing information with them. They'll be sharing information certainly with you. And you may have in those agreements very explicit restrictions. And we'll talk about that. But even more likely is that there won't be explicit restrictions in there, but there's always been AI-related contractual obligations. Let's talk about some explicit restrictions. So here is an example, where it says you cannot use AI directly or indirectly in connection with the work product. This makes sense, if you are delivering something that the client expects will be original and that they'll be able to own 100% exclusive rights to. You can only do that if it's not AI generated. If it's AI generated, they can't own the exclusive rights to it, can't be protected. And so they will have something like that. It's more likely, though, that you'll see the inverse. It's more likely that they'll say something like, you will have access to our confidential information, and you will not use AI to process any of our information. And the reason they want that is because of what we just saw in our terms of use, that we don't know what protections there are. Are you opting out in the right places? Do you have the right account type? They don't want to worry about that. They're just going to say, don't use any of my confidential information or my data in AI tools. And, if you are using one, some of the ones that people suggested, then that opens the conversation. Like, okay, I will be using it. And then they'll be able to decide whether or not they have enough protections and it works for them.
Erin, could I ask you a really quick question about this clause that you just put up here? Like, when it says not to use or integrate directly or indirectly, does that include, like, for example, helping edit? Like, I write something. Just today, I was writing a proposal, and I was using AI to help me condense it. Now, I look at AI suggestions. I might use some of it, or I just change it. What does that mean if I just use it to help me write as an editor, essentially?
Well, is it part of the work product or deliverable? Is that the thing that the client is paying you for? And so if it's the thing that the
let's say it
client's
is, I'm
paying,
writing a report for them instead of a proposal.
yeah. So if you had this language in there, they would want to know that. Now, what's interesting is, we've been using things like, autocorrect and Grammarly and things like that forever. And as it has become more generative and kind of, adding, working more autonomously, there's like a spectrum of what their expectations would be. And so at some point, we would need to kind of judge, like, am I just using this to proofread, or am I using this to actually add substance of some sort? And then it also would depend on the deliverable as well. Like, is this something that they would be using publicly? And therefore, they would need to be really sure that there's no chance that someone's going to see a white paper that they release and it's got somebody else's information in there. So there will need to be some kind of discernment about when and how you use it as well. And then, so even if there's no restrictions, and I will say, I review a lot of agreements, and I really don't see that many client agreements, corporate client agreements, that have restrictions in them, explicit restrictions about the use of AI, which surprises me. I've been kind of expecting it for a couple of years now. But in any case, we still have obligations in the provisions that have always been in all of the agreements and will always be in the agreements. And included in them are confidentiality obligations. So you get confidential information from your client, and it will say you can only use it to perform the services, and that you can only disclose it to, directors, typically people inside of your business, maybe advisors like your lawyers or things like that. And that you share it only on an as needed basis. Now, this also goes to your point, Bernardo, from, when was something just a technology tool that we're sharing it with versus are we sharing it with a tool that is actually adding to the advice that we're providing or to the deliverable that we're providing. And there is an argument to be made that when we are using it to help create part of the deliverable, that is a third party, and that's a third party contractor. Like, let's say you were writing a paper and you used a subcontractor to help you write part of it. That would be very clearly, you would not have any doubt that that's a third party. And are they included in this list? And they're not included in this list. You would need to have permission to share it with contractors in that list. And so it can be that if you're using AI to create part of the deliverables, that you are in breach of your confidentiality obligations if that's not listed here. In addition, there'll be the data protection obligations that we have. And your clients will, whether they are, whether you or they are subject to GDPR or HIPAA or CCPA, the best practices are to have data minimization. And so that you're not going to process the data any more than actually necessary. So this is language from a SaaS agreement that I reviewed recently for, in this case, it would have been for the customer that I was representing. And they had this AI-powered solution. And the client, my client customer here, did not want them to use any of their data to go into AI. And so they're like, oh, no, don't worry about it. It's only de-identified, and it's only for the purposes of training, and it's only for these things. Well, whoops, what did I do? Well, does that matter? In a couple of ways, it doesn't matter. I'll tell you that, first of all, data minimization means we don't process the data any more than we absolutely have to. And de-identifying data is processing. If I have a list of customers and I have no need to have them in a de-identified format, the act of de-identifying them is processing them in a way that exceeds the need for the services. So that in of itself would be a breach of your obligations to only process that information for the services. And also, if it's de-identified, does that help you if you are, talking about your secret sauce and you're putting that in there? The fact that it's de-identified doesn't matter if the ingredients of your secret sauce are there. And so we need to also make sure we're mindful when we're using a tool that is going to be processing your client's data, that they don't have these kind of pretty carve outs about how it's de-identified or aggregated, if that would be in breach of your data minimization obligations to your client. And then reps and warranties. We've all seen these, depending on the nature of the service that you provide, of course, originality. It's your own work. It's free of errors. It doesn't violate third-party rights. These are not representations and warranties that you can make with respect to output that you haven't put enough original layer on top of it. So again, maybe you use it to create an outline, but then you use your own expertise to fill it out, turn it to a fully fleshed report that you're presenting to the client. But if it's something that's coming straight out of your AI tool, then it's not original. You can't say whether or not it's published before. And we know that AI tools hallucinate. And we don't know whether or not they could violate third-party rights. So these are reps and warranties that are hard to create, as well as just kind of a general competency and professionalism. Are you delivering services in a way that is in accordance with industry standards? That's a very common representation and warranty that we'd be asked to make. And does this comply? And so in the event that it doesn't, obviously we're in breach, but if using AI is very new and not expected, then that would be another reason to disclose and to get consent. All right, I'm gonna stop there to see if anyone has questions about what I just covered. Okay, all right. So let's talk about statutory obligations. So like data protection, we do not have federal regulation. And interestingly, as we record this at 6:47 on June 30th, there is a bill in the Senate called the Big Beautiful Bill that has a provision in it that is very important regarding AI regulation that not everybody is aware of. But in it, there is what was originally a 10-year moratorium on state regulations of AI. It is being negotiated, like many of the provisions in there. The last I heard as of this morning, it was down to a 5-year moratorium. And there was a carve out for deep fakes. And that was generally driven by Tennessee, has what they call the Elvis bill that protects basically the Elvis industry to make sure that you can't, kind of take his face and image and voice and create fakes. And so that is the last that I heard as of this morning of what's still in the bill. So all this may not matter depending on what happens. But as of right now, there have been a few states that have passed some regulation. Most of them are with respect to the developers, the OpenAIs of the world, the Anthropics of the world, not so much with respect to the deployers, as they say, the people who use it. Colorado has one of the most developed AI regulations with respect to deployers or users of AI. And that is for those who use it in a high-risk environment, which we would be in working with, employment issues, with healthcare issues, with legal services. And so, and it does require us to, be very mindful of bias. We'll talk about that some. Disclosures, impact assessments, and transparency for how decisions are being made. I think I got to think about the state regulations. It passes year one, but it doesn't come into effect until later. And that is the case with Colorado. Virginia had one that was very similar to this, but it was vetoed. It was passed through the legislature, vetoed by the governor. Maryland has one that's coming through that's similar. So if there is not a moratorium placed on AI regulation federally, then do expect that your state will have something that may apply. All right, so that takes us to transparency. And so, you know, whether you have legal obligation because you're contractual obligations or statutory obligations, or part of your professional kind of certifications, or what's the best practices in your industry, you know, having consent, having transparency is really important. You know, it happens with respect to the recording. When we started this Zoom, a couple of times it came up that one, it was being recorded, another time it was being there, a transcript was being created. And that hasn't changed. That's always been the case, that when we're being recorded, some states are two-party consent, meaning both, and this assumes two people, but that both parties on the telephones where it comes from have consented to the recording, but that would apply to everyone on this Zoom call. Some are one-party states, but the requirement to have consent remains. Also, some states have data processing, we've talked about, others do not. Regulations, but you know, how we're going to process it. Are we practicing data minimization? Who will have access to it? How long will we keep it? What will we do with it? These are things that people would expect to have transparency regarding. Some of these things are addressed in a privacy policy. We all kind of should be familiar with privacy policies. But typically, you know, in the environment that you're working in, you're not going to have a client or one of their employees looking at a privacy policy. So we want to have these things addressed in the consent. So interestingly, again, Blueprint was shown to me earlier today, and I had they had this. I'm going to share with you a consent in there. Oops, that's not what I want to do. Blueprint. So Blueprint is for therapists, and but also I did prepare a more general one that you can find here, but that really covers kind of all of the bases. Okay. Oh, where am I? Okay, here we go. And so with that, I'm going to take us to E&O insurance. And E&O is interesting. Errors and omissions, also called professional liability insurance. And as you know, hopefully you have it. Malpractice, perhaps as therapists, as psychologists, you may also have be called malpractice insurance. But at the end of the day, humans, no matter how well intentioned, sometimes mistakes can happen. Sometimes our advice goes awry, and we have E&O, professional liability and malpractice insurance, to cover us in those instances. Question: does E&O insurance cover errors made by AI? Now, cyber liability, people think, oh, I got cyber. Well, cyber is when things go wrong with technology. When we're using AI, everything goes absolutely right, exactly the way you put in your inquiry or whatever the information is. It gave you a response, you passed it on to your client, and it was bum advice. Does your E&O cover that? And that is a question that is still being determined. There are a couple of fairly famous cases recently. You know, in fact, there was some lawyers who were part of one of these AI related litigation matters, and they used a brief that was written by AI that they didn't double check and submitted it to the court, and they were not amused, as you can imagine. There have been insurance providers who use some sort of AI tool to recommend the level of coverage that a client needed, and it was too low. Catastrophe happens, the client is underinsured. Who is that covered by E&O? Is that considered regular negligence? Is that gross negligence? How much oversight is required? So these are things like, as you are thinking about your insurance, I want you to be talking to your broker about that. And then finally, let's talk about bias. And I know we're getting to the end here. So bias, AI has bias built into it because it's based on what is, think about the resources that have been used to populate the training data. We hear from New York Times, and we hear from trying to think of some of the other places who have sued them, like like some of the studios and Authors Guild. Like, where is the data coming from that's part of that data set? And it is from these very large pools of data. And so they will have these biases built in based on where they got that data set. And so we need to be really careful about how we are using that output again. Even if something that's not as explicit as making all CEOs white men, but there are other things that can be triggers for bias. There is currently a lawsuit against Workforce, I believe, because people believe that they were filtering them out using their AI tools, and things like zip codes, things like culture fit, things that can also cause this. Here in the middle here with business impact, I was really shocked to see these numbers that people are really deferring to AI. It is absolutely shocking to me, but it makes it even more important. I feel like this is more applicable to you working with your clients than what you would do. I don't think any of you would do this, but when you're working with your clients, knowing that AI is a big part of their decision making. Now, this was a survey of 300 CEOs of like kind of Fortune 100 companies, but which makes it even more alarming, frankly. But that they would defer so much of their decision making to AI, and so that brings us to agentic AI. So what is that? That is AI that can act autonomously, that you can give it a task and give it, whatever it needs, and then it runs off and does it on its own. And there would be no human oversight generally if it's truly agentic. It can act and make decisions and proceed to the next step without any human interaction. And that is a big problem. One of the concerns that a number of you had is, how do you make sure, I have to go back and read them, but about how to keep from the profession being pushed in this direction of using AI and taking out the human element. How do you get your clients to trust and making sure that you are staying in control of that whole process is super important. It's one thing to use agentic AI to respond to some kind of standard inquiries about, your rates or something. It's another thing to replace your own expertise with it. And so while I'm a fan of AI, I am not a fan of agentic AI. I think it's has no place in people who provide professional services, frankly. And so in sum, I would just say that, human oversight is essential to the ethical use of AI. So I'm going to stop there because I've gone over.
Erin, that was absolutely fantastic, and I'm equal.
I feel like I just sprinted. I got to say that.
I was going to. I'm equal parts continuously just impressed by all of the tools that are out there and the advances, and also simultaneously terrified by everything that is out there. You've given us a lot of food for thought.